you trying to understand whether an agreement of sale should be registered or not? Are you trying to understand what are the advantages versus what are the disadvantages of registration or non-registration of an agreement of sale? Or are you in a situation where a party to an agreement of sale is not complying with the agreement of sale and you're worried that the agreement of sale is not registered and what will happen if you go to court? If these are the things that you're thinking about, then you're in the right place, because in this video I'm going to be talking about what is the general rule and then what is the exception and what are the nuances when it comes to registration versus non-registration of an agreement of sale. Hello everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and more legal information, make sure to hit the subscribe button below. So before we talk about the advantages and disadvantages, let us talk about why most people don't get an agreement of sale registered. What is the reason? And why are all these exceptions coming into play? Well, the biggest reason why most people don't register an agreement of sale, because unfortunately the sad reality in India is that the majority of real estate transactions involve some amount of black money. They involve some amount of a cash component which is not reported to the income tax authorities and whatnot. So in this situation, so let's take an example. So let's say that, suppose that I'm the seller, you're the buyer, and you're trying to buy a villa, an apartment, or some piece of land, or whatever, some property. Now, when you come to me, let's say the deal is for 2 crores, then more likely than not in India, what generally happens, unfortunately again, which should not happen, but that's what happens, is that the seller says, look, I will take 1 crore in cash, 1 crore through a bank transaction, and so that I can not report the 1 crore in cash. So that's the reason why people don't register the agreement of sale, because the agreement of sale between you and me will most definitely say that the deal is for 2 crores. Because at least between us, to bind ourselves, we will sign the agreement with the correct figures. Now, if we go to the registration authorities and we execute or we register the particular agreement of sale for 2 crores, then we will be bound by that when we enter into the sale deal. So therefore, most people don't register the agreement of sale because of there's this particular cash component. That's reason number one, which I think is the biggest reason why most people don't register. Reason number two why people don't register is because if you register an agreement of sale, then there is also some additional stamp duty that is payable to the government. So it could be 1%, 2%. So for example, in our case, if you register an agreement of sale, let's say if it's 1%, if the deal is for 2 crores, then you'll have to pay say 2 lakhs to 3 lakhs just for the registration charges. And this is another reason why people don't register the agreement of sale. But these are the top 2 reasons why people don't generally register an agreement of sale. Now with that out of the way, let's talk about the general rule before we get to the exceptions. Now the general rule in India and in Telangana is that if the property involved is worth more than 100 rupees, then any document that concerns that particular property has to be registered. Now I don't think there's any property in Telangana, let alone the entire country, which is worth less than 100 rupees. So any document that touches that particular property, it could be an agreement of sale, it could be a sale deed, it could be some kind of an MOU, it can be a development agreement between a landowner and a developer. Any document that involves property more than 100 rupees has to be registered. But people who make these laws, our lawmakers, our legislators, they also understand that there are a lot of people in say tier 2, tier 3 cities who are not aware of these legalities. And even today, it is a fact that a lot of people, even today, they enter into sale deeds and agreements of sale on simple white paper, not even a stamp paper. And due to ignorance and just because people may not be so well off in these places. So having understood this, our lawmakers have carved out some exceptions when it comes to non-registration of an agreement of sale. Because on the one hand, they need to balance, clarity in the public record, because if something is registered, that gives notice to the whole world. So they need to balance that with, the realities of our country where people are not very aware of their rights and their laws. So the general rule is, yes, you have to register, but there are some exceptions. Now, what are these exceptions? Now, I think the exception is best understood with an example. So let's continue with the same example. Let's say that I'm the seller, you're the buyer. The value of the apartment that you're buying from me is 2 crores. You come, you pay me 1 crore. crore and we enter into an agreement of sale which says 2 crores, that the total value is 2 crores, that you've paid me 1 crore and that there's a balance amount of 1 crore that is pending from you to me, and that I will, within 3 months of the execution of the agreement of sale, I will come forward and I will register the sale deed in your name. So let's say that we enter into the agreement of sale on the 1st of January. We have until the 31st of March. Within that period, you need to pay me the balance 1 crore. And as my obligation is that I need to come forward to execute a sale deed in your name. Now, let's say that the agreement of sale is not registered. And 3 months have passed. You've been, chasing me that, Ramana, please come forward and execute the sale deed. But having taken your money, I'm happily sitting, I'm not interested. You're like, whatever. I'm not going to register the sale deed. Now, in that situation, what do you do? In that situation, what you do is you go to a lawyer and you say, look, Ramana is not coming forward to execute the sale deed in my name. So I want to file a case against him. So the case that you will file against me, most likely, the case that you will file against me is a case for specific performance. So what you will do in that case is you will seek a direction from the court and you will say, please direct Ramana to come forward and execute the sale deed in my name because I'm the purchaser. I've already paid him 1 crore. I'm ready and willing to pay the balance 1 crore, but Ramana is not coming forward. So please issue a direction to Ramana, first of all, to execute in my name, and also number 2, not to execute in any third party's name while the suit is pending. So this is what you will be asking for. Now, I show up in court and I say, the agreement is not even registered. The agreement of sale is not even registered. So this court can't even look into it because we know the general rule, which is that if a property is worth more than 100 crores, it can only be any document touching that has to be registered. So the question is, can I come to court and just take that argument saying that it is unregistered, therefore cannot be looked into, cannot form part of evidence? Now, to understand this situation, the number one thing to consider is whether the agreement of sale that was executed, whether I had given possession to you at the time of agreement of sale or if no such possession was delivered. Now let's take, in our case where 1 crore is still pending, it is likely that I have not given possession to you because 1 crore is still pending, so I'm not going to part with possession of the property. I'm not going to give you access to the property to just go move in there because 1 crore is pending. But if you modify the facts a little, so let's say that out of 2 crores, you have already paid me 1 crore and 97 lakhs when we enter into the agreement of sale. So only 3 lakhs is pending. Now in such a situation, I may have given you possession of the property because only 3 lakhs is pending. And you have taken possession of the property because you've paid a majority of the amount and what's left is just a minor thing. So the first thing to consider, or when you're thinking about whether this unregistered agreement of sale is admissible in evidence before a court, the first thing to consider is to think about whether possession has been delivered along with the agreement of sale or if no possession has been delivered. Now, in a majority of cases, possession is not delivered. So let's tackle that first. So if no possession is delivered, in that case, the agreement of sale is admissible in court as evidence in a suit for specific performance, which basically is a suit where you seek direction from the court to direct Ramana to come forward and execute the sale deed. So if it is an unregistered agreement of sale and no possession has been given, then even though the document is unregistered, it is still admissible in evidence. But some things to keep in mind here. This only works if it is a suit for specific performance, but it will not work for other suits. So let's say that, instead of the villa, let's say that you're buying a factory from me and I refuse to come forward to execute a sale deed in your name. So instead, and my factory is located in the outskirts where your trucks can come and go easily. They can just take the ring road or whatever, and then they can leave the city easily. But since I don't come forward, you have to go and you need to, you purchase an alternate factory that is somewhere deep in the city where there's a lot of restrictions on movement of trucks, that they can only come in the evenings and so on, and because of which you suffer losses. And let's say that you come and sue me, let's say, look, because Ramana did not come forward and he did not execute the sale deed in respect to that particular factory, I had to look for another factory, and because of that I have lost out my profits in the business that I would have generated. Therefore, Ramana is liable for damages. Now, the thing to understand is that this is a case for damages. This is not a case where you are saying, please direct Ramana to come forward and execute the sale deed. Now, in a case for damages or in any other type of suit except a specific performance suit, the agreement of sale will not be admissible. Now, it will not be admissible. I mean, it will be admissible only for a specific purpose if it is not a specific performance suit, which is only for a collateral purpose, which basically means that, I will accept it that there was some oral agreement between you and Ramana to buy and sell property. But as the court, we are not going to look into the terms of the agreement of sale. We are not going to look into, that there were 2 crores payable, 1 crore was paid, that there was this particular time period. We're just going to think about it like, there was an oral agreement between the both of you, but it's just, so we're not going to look at the contents of the agreement of sale, which again for you is not a great position to be in. So in any other suit except in a suit for specific performance, it is not admissible except for a collateral purpose, which basically means that there was some agreement, but we don't know what the agreement is and they will have to really prove it. And we're going to treat it as though it was just an oral agreement. But if it is an suit for specific performance and no possession has been delivered, in that case, it is admissible in evidence even though it is not registered. Now let's move on to the second case. Let's say that for that villa or that apartment, you paid me 1 crore 97 lakhs and just 3 lakhs are pending. Now in that case, I've already delivered possession to you, where I said, you can move in there. We can do the sale deed by the 31st of March. But on Jan 1st, you paid me this much money. You can move in. No problem. But 30th, the 25th of March rolls around, 20th of March rolls around, you're following with me, I'm not coming forward to execute the sale deed. Now, in that particular case, where I've already given possession of the property to you, the question is the unregistered agreement of sale still admissible in court if I don't come forward and you want to come sue me? Now, again, if it is a suit for specific performance, then even if possession has been delivered, you can sue me for specific performance and you can take the unregistered agreement of sale and it is admissible in evidence. I cannot just show up and say, the general rule is more than 100 rupees has to be registered, not admissible. That will not work. Again, only in a suit for specific performance, not for any other type of suit. Having said that, so, you can ask me, Ramana, but if no possession has been delivered, it is admissible. Possession has been delivered, it is admissible. Then what's the difference? Well, the difference is that if possession has been delivered, the law confers some additional benefits on the purchaser. Now, I don't want to get too technical in this video about this, but there is a particular provision under the Transfer of Property Act called 53A. 53A basically talks about if an agreement of sale has been entered into and a person has already taken possession, or if a person was already in possession of the particular property, but he's made some further improvements to the property, or let's say that in our case, let's say that in the 1 crore 97 lakhs case, let's say you were already a tenant in that particular property and you paid me 1 crore 97 lakhs. So you're already in possession, but I'm still not executing the sale deed. Now, in that situation where you already paid a majority of the consideration and you are already in possession, the law gives some extra benefits to you as the purchaser. But if the agreement of sale is not registered, then whatever those extra benefits that the law gives you by virtue of that section 53A, those benefits cannot be that you cannot go and claim those benefits if the agreement of sale is unregistered. Now, I don't want to get too technical as to what these benefits are, but I've put a link in the description of a Supreme Court case and a Madras High Court case where they talk about this. So if you're interested about that, check it out in the description. So just to give you the big picture, if possession is not delivered in a suit for specific performance, the agreement of sale is admissible. If possession is delivered, again, in a suit for specific performance, the agreement of sale is admissible with some nuances where those extra benefits of possession, those will not be given to you if it is not registered. Now, at this point, you may be thinking, whatever these benefits are, there's some nuanced issues. What does it really matter? Like, if I don't get it registered, is there really no benefit to get an agreement of sale registered? Like, what is the big benefit that I will get except for these nuanced things? Well, I will tell you that there are two big benefits that you get if you register your agreement of sale. Number one, and I think this is the biggest one, which is that it will enter the public record. So let's say that, I'm a crooked seller and, you are an innocent buyer. You pay me 1 crore and 1 crore is still pending. And this is the 1st of January. Now I'm thinking on the 10th of January, this purchaser, he doesn't know much. He's a newcomer to this city. He's a software professional or he's just an employee or whatever, I think I can screw him. So let me do something. Let me go and, because this agreement of sale is not registered, right? So it will not show up in the public record. So I will go and I will sell the property to a third party. I will enjoy his 1 1 crore. And when he comes to me, I'll try to settle him, say, you know what, I've already sold it. You want to go to court, you go to court, and we'll fight it out in court. It'll take 10 years, 15 years. But instead, out of 1 crore, I'll pay you 50 lakhs or 70 lakhs, 30 lakhs, you forget it. And then, we'll just settle it. Now, this is possible only if the agreement of sale is unregistered. If the agreement of sale is actually registered, then any prudent third party, before buying, he would check the public record. And he would say, you know what, Ramana, how can you come and even offer this property to me? There's already an agreement of sale that you've entered the purchaser. How can you come and try to sell me this particular property? That is not correct. And no prudent person would touch that particular property. So that's one of the biggest benefits of registering an agreement of sale. The second benefit is that while an agreement of sale is admissible in a suit for specific performance, in both cases with possession, without possession, when the document is admitted during evidence, they will still collect a penalty from you. So if you are the buyer and you want to press the agreement of sale into evidence saying that, look, Ramana has to come and pay. I mean, Ramana has to come and execute the sale deed. I'm ready to pay. Then because you are relying on that particular agreement of sale and it is unregistered, they will ask you to pay a penalty, which is generally pretty steep, on the stamp duty that was originally payable. So while registration cannot happen because registration can only happen within a particular period of execution of the document. But if you forget about registration, even as far as stamp duty is concerned, for stamp duty, you will pay a steep price when you press that agreement of sale into service in the court. So although it is admissible, you will end up paying, a steep price for it. But you can still sue me for specific performance. So those were the advantages and disadvantages of registering versus not registering an agreement of sale. If you found the video helpful, make sure to hit the subscribe button below. Thank you for watching.